Are we phoning Mark in?
Yep. Can you
Oh,
hear me?
you're here. Yay. Technology
All
is
right.
great when it
Well,
works.
I'm excited to be back. It's been fun all day watching everybody present. I wish I were there in person. But as I talked about earlier, I met with someone on Monday that turned out to be exposed to COVID, and I found that out yesterday, late in the day. So decided it probably not a good look for a healthcare lawyer to be at a
Spreading COVID at a CLE. Yeah.
Just got to be careful. So we're going to turn now. If Chris, if you could get us on to the agenda. There we go. Some of you, before I get into the agenda, you might be wondering what UFTA means, and I think about this next part of the presentation as UFTA, and I'll just read from Wikipedia what UFTA means. It's an exclamation or interjection. Well, actually, before I do that, let's poll the audience. What do you think UFTA means? And I think Tracy prepared a
Oh,
quiz.
good.
Yeah, so I won't give that away.
What's the question?
What does UFTA mean? And the responses are: is it another word for sneezing?
Okay.
Is it a made-up Norwegian term, or I have no idea?
A,
So
B. What do you guys think? I'm guessing most people know this. We're hearing B on the floor. What? C? Okay.
Polls closed at 85% think it's something Midwesterners say.
Yeah.
okay.
19% have no idea. And I don't know
Okay.
where the other, I don't know.
That's funny.
We have an extra 4% in the poll. I don't know where this is coming from, but
Okay, well, bad math. UFTA means it's an exclamation or interjection used to express dismay, typically upon hearing bad news. Or of Norwegian origin, the phrase was brought by Scandinavian Americans, which we have a lot of in Minnesota, to the upper Midwest, New England, and Pacific Northwest regions of the United States during the 19th century. So UFTA, this next part of our program, you're gonna be saying UFTA. So we'll talk about trends. We'll talk about some AdvaMed updates, transparency reporting updates, recent cases, which will be the big UFTA part. Then Mallory, and then a bonus topic is responding to investigations. We're gonna try and go through this really fast.
Yeah, I was going to say we can try to go as fast as we can. But yeah, you guys have slides too, so.
So, and Amanda, I don't know if you can advance the slides there. Or
Yep.
Chris, great. So before we start, Amanda and I were literally called the doom and gloom twins by another attorney on a conference call,
Yep.
I don't know, a month ago or so. It
Yep.
said that we reside in a black hole. And I
Yes.
had to pull that into the deck.
This is
here.
true.
So we are trying to remediate our reputations by balancing the information we share. So let's go to the next slide. Here's a picture of a puppy. How cute is it? It's not scary. So let's go to the next
Yes,
slide.
we want to start with good news. Cute
Start with
things.
Good news, and then we're going to quickly depress. So these are the trends that we're seeing in the industry. I think everyone knows the off-label cases have been on decline, since Howard kind of rung their bells in his case, and that I feel like I think there has been a declination of cases, although there are still some around. But FDA is continued to lose on FDA First Amendment off-label cases. But we're seeing a definite uptick in the adulteration cases and misbranding cases. So FDA's bringing they're getting DOJ, and DOJ's involving other theories like adulteration, products made wrong, or the labeling's wrong. It's not truthful. It's false and misleading. We continue to see a ton of cases around anti-kickback, False Claims Act. So if you violate the anti-kickback statute, you automatically violate the False Claims Act too. That's written into law now. So free stuff to doctors, watch out for that. I know we have a lot of watchdogs, if you will, as part of the meeting here. A lot of the cases continue to be driven by whistleblowers. I had a friend who's a compliance officer at a very large healthcare company, and he was asking me, "Hey, did you hear about this this hedge fund that was put together to basically be a whistleblower hedge fund?" And so their aim is to just find whistleblowers and then help them bring suits against companies, and with the hope
Scary.
to make lots of money. So I was like, "Are you kidding me?"
Yeah.
And I'm sure he wasn't making it up. So just like one example that's pretty recent, it's from 2020, a little less than 2 years ago. The whistleblower in that case stands to gain 110 million bucks. So, not a bad day's work or year or two work. And then we're starting to see the Sunshine Act cases ramp up as well. So I'm going to hand it over to Amanda to
Yep.
talk a little bit more about this.
Yeah, my professor in law school who taught FDA law, Ralph Hall, I don't know if any of you know him, but he used to always say, like jokingly, that he wanted to retire and be a whistleblower. So I doubt he will, but it's a good payday. All right, so we'll talk quickly about AdvaMed. Some of you may have seen that they issued an updated and revised version that goes into effect on June 1st. They added quite a bit of content, but I'm going to focus on kind of the key updates. Alcohol is always a hot topic. So no, they did not ban alcohol like Pharma did, so that's good news, I guess. But they did add an FAQ that more explicitly says that companies should add in controls and processes around alcohol at company events. So things like, 2 drinks maximum, or having like tickets, or restricting just to beer and wine, that kind of thing. So something to think about in your interactions with HCP policies. Virtual interactions was also added, which was good because look at us today. We're a great example of the virtual world that we live in now. So there's they've explicitly allowed for virtual interactions, and they called out some specific rules around meals, like no home delivery, but you can, deliver meals to like a clinic for example, if you're doing kind of a company program or something like that. So if they're all together and the rep is not there. They also added quite a bit about value-based care arrangements. And so the safe harbor, the anti-kickback statute, safe harbors were added to address value-based arrangements, which really are widely not available to manufacturers. But they did want to kind of, as a nod to those safe harbor updates, they did incorporate some concepts. So these are kind of the 3 key updates. I would recommend, looking at your policies and seeing what needs to be updated or aligned to accommodate these updates. The Sunshine Act, so this has kind of quietly been in the background. When the proposed rule came out, it was kind of a hot topic because they had added a definition for physician-owned distributors, so PODs. So as many of you know, they kind of have a bad connotation with the DOJ, and they've issued some special fraud alerts about PODs. But they did, all of it passed into the final rule. So these changes are coming into effect. So it'll be calendar year 2023, and then reporting in 2024, March of 2024. So here's kind of the long list of key changes. There's actually more. So I would encourage you guys to go in and check out and make sure that your processes are going to be, set up and ready to comply for 2023 calendar year. Let's see, is there anything else interesting in there? Yeah, a lot of it's administrative, but there are some like clarifying the exception. There's some clarifications. But yeah, nothing too earth-shattering, except if you are except if your company meets the definition of a pod, then you have to basically say that you're a pod, which it'll be interesting to see how that kind of shakes out with anti-kickback statute. Even though CMS explicitly said that this definition only applies for Sunshine, it's just kind of interesting to see. It'll be interesting to see how that plays out.
I was just going to comment too, Amanda. There's little tweaks in there, other little changes.
Yeah.
Rules around publications and short-term loans and things. I think one of the takeaways is that the Sunshine Act has continued to evolve over the years. So if you haven't, if you haven't looked at your policies and procedures since 2013, it'd be smart to go back and look at your definition of, who's a covered recipient.
Yeah, absolutely.
A few years ago, they pulled in certain types of nurses and whatnot.
Yep. And we, have to mention state transparency reporting as well, so just don't forget about it. although it's interesting, with the expansion of the definition of covered recipient under the Federal Sunshine Act, we haven't heard a ton about how, like a lot of the things that we probably would have previously reported to states are now going to be preempted because we're reporting them to federal. So I haven't seen a ton on that, but I think it'll just be a smaller pool of people you need to report on or entities. Like, for example, Massachusetts has a pretty broad range of covered entities or covered recipients. So just something to think about, and it's reporting season now. So June 1st is June 1st is Nevada, then we have July coming up with Connecticut and Massachusetts, so.
Yeah, so just another quick comment. You see all the states at the bottom there, they all have
Oh, yeah,
some rule. We counted them up for you yesterday. There's 26. So Amanda made the comment, we should start talking about the states that don't have restrictions. But like some of them are, obvious. We all know about Vermont, no meals to any HCP anywhere. But New York has the same rule, but it only applies to state employees. So I remember being in the lab like 20 years ago and trying to buy a lab director a cup of coffee for like 50 cents, and she said, I can't accept it. So knowing those little nuances are important. Tim also commented briefly before about federal gifts, and there's something called the 2050 rule, limits gifts that federal employees can receive to $20 per instance, up to $50 in aggregate per year. So a lot of companies just say no gifts to federal employees just to make it easy. And there's all kinds of other wacky, little nuances in all these other states. So just something to be mindful of. All right, I think I'm going to go, and Chris, if you can make the font black again on these, that would be awesome. I have notes in front of me, so if I look like Walter Cronkite, it's because I'm looking down notes. That joke probably falls on deaf ears if you're younger than 45 years old. But so the first one is Medicrea. It's a French company, and I'm going to really go rapid fire through these because we want to get onto our panel. But essentially, this was a device company that was inviting consultants over to France, and they're kind of whining and dining them. Thank you, Chris. And bogus consulting arrangements. By the way, all these settlements I'm going to talk about, they're all alleged, right? So these folks all settled out, all these companies. But that was the first one. So the company was kind of taken off guard because they thought, hey, we're in France. Well, you also have the FCPA to worry about. But they ultimately settled under the AKS FCA because these were American physicians. But if they were bribing, foreign officials, it'd be an FCPA issue. So the Sunshine Act also wasn't followed. They didn't report this. They might have thought, hey, we're outside of the US, so it doesn't apply. That's wrong. Again, I'm just going to go rapid fire. The next one, Medical Designs v. Seekage. This is the steakhouse case, in case you heard about it. The physician
Brazilian
owned
steakhouse.
and they just kept doing dinners at his steakhouse, Carnival Brazilian Steak Grill and Brazilian Grill in South Dakota, but didn't get reported to Sunshine. Remember, that's an indirect payment. So since the physician owned the restaurant and ultimately the payments behoove the physician, those payments are indirect payments that should have been reported. They also settled under AKS, under the AKS, because they said, hey, you're using this restaurant to really drive business. Alliance Family and Companies, they were providing free services. They were interpreting test results for free. So, you're getting physician services ultimately. Government said that's a kickback. They should have been paying for that. This was also uncovered during diligence, and it was not stopped after diligence. So think of that if you, I probably don't have a ton of bankers on the phone, but or on the webinar here, but if you are strategic and you buy a company, you uncover something during diligence, you should stop it if it's violative and then determine whether or not you have to report as well. You might have to report that to the federal government. Lastly, last point on here is just that the White House has a memo on anti-corruption out, and that was put in place shortly after it was in 2021, but the administration, it's on their radar. Turning then to the next, again, continuing the rapid fire. Merit Medical this case was really all about practice building. So that's, helping your customers get more patients. The government views free ads, free marketing, free practice development as a valuable thing that companies are provided for free. If they're doing that for free, then that's a kickback issue. So they entered an $18 million FCA, False Claims Act settlement. Because like I said before, if you violate the anti-kickback statute, you violate the False Claims Act. And they're also in a CIA, that's Corporate Integrity Agreement, extremely disruptive and expensive. They last usually 5 years. And it means that someone's going to come in, an IRO, and audit you every year to assess your compliance for 5 years. Let's see. Oh, they also ostensibly said that the payments were education. So watch, keep an eye on your marketers. They may try and say, hey, this is education. Well, if it's a valuable thing, then the government's going to think otherwise. And I'll pick on marketers because I worked in product management at a couple different companies before starting to practice law many years ago. The next one, Gilead, this is around a copay, so I won't get too much into the facts on this, but $100 million settlement. And the government said, you set up a copay / foundation, or a foundation that covered copays. And you're really, you're ostensibly, again, saying this was to really help the indigent and whatnot who can't afford your drug. But it turns out that everybody that got assistance from the foundation ended up getting on your drug. A lot of times companies like to set these up because they don't want physicians to say, hey, I'd prescribe your drug, but I can't get it covered. And then the patients come back and complain to me. So companies will say, well, we'll just set up a foundation and that'll cover the drug. And then we'll get the insurance companies to cover that, to cover the drug as well. And for those that don't, we'll just send them to the foundation. So the government's been all over those types of programs. There is a lawful way to do them, but you need to be careful, and it can't just be designed as a conduit to get your product to people to cover the cost of the product when they can't pay for it. It should include other types of other options, and you can't tell the foundation what to do. Novartis, this is a pretty famous case. Probably a lot of you are aware of it. And this was really the driver. I think this was kind of the straw that broke the camel's back and wound up creating the special fraud alert from the OIG on speaker programs. And this has, the complaint had all the typical stuff: going to Hooters, fishing trips, top shelf alcohol, no controls. The government loves to find out when somebody buys a bottle of cake bread or whatever it is that, Silver Oak, something real expensive, and just whining and dining doctors. That's what this case was. At $275 million settlement. They also said that you're just paying speakers to come to your social events and drink wine, and there's no legitimate activity at these events. Many times they're saying you're doing them for one person and you're not even talking about the drug. So government clamped down. Think of how disruptive this would be to your business. Under their settlement agreement with the government, they can only do virtual meetings, no in person. They can only do them for 18 months after FDA approval. The maximum amount they can do on a drug is $100,000, which we all know is nothing for promoting a drug. And it's $10,000 for speakers. So they essentially shut down their speaker program. Let's go to the next slide. Okay, I know this is where the doom and gloom comes in, Amanda. This is why we are referred to as doom and gloom. So we'll talk about Pacira, and a few more cases here. I have so many. I'll have to start going even faster.
Yeah.
Pacira involved a pharmacist that blew the whistle. And he said, hey, we're being offered these grants, and there's no milestones for the grants. It's bogus. So make sure that if you do have a grant program, that it's legitimate and that it's actually the grants are for a good reason. They're being provided for a real reason. Mallinckrodt, this one's also a similar copay type arrangement where the government took issue. The compliance officer, who got any compliance officers out there? The compliance officer blew the whistle. So they're gonna, if they can extract money from Mallinckrodt, it's now bankrupt, but they'll see a big payday. DUSA, Sun Pharma. This was actually one of the off-label cases recently, and they were promoting allegedly off-label during speaker programs. promoting a contraindication. So paid a $21 million settlement there. A few more, and we will. Actually, I have so many more. I'll have to keep going. I think the point here, I could summarize this entire slide actually. As I mentioned earlier, the FDA cases are ramping up. So it's no longer just your, sales and marketing people that you have to worry about bribing doctors. It's actually if your QMS is messed up because you're mislabeling products and misbranding them, or you're not making them product properly, or you're not disclosing complaints in a way that the government likes, you may be facing a False Claims Act case. And we are seeing these in the background ramping up. We're involved in one federal case but obviously we can't get any of that, but we are seeing these cases coming up. I'm hearing from people, gee, FDA is just camping out here. What's going on? Are you seeing this? They're asking for a lot of quality information. Well, there's a decent shot that someone's blowing the whistle and saying that the product's being made wrong. So more good news for industry that there's even more scrutiny on it. The last one there is also another off-label case. Let's go to the next slide. Privacy ramping up. Maybe in Paul's next program, they'll call him. We'll have to come up with another name, doom, gloom, and
exactly.
But we're starting to see the privacy cases come up. You're just seeing crazy laws on point where governments are saying we're going to take 8% of your gross revenue to fine you. It's just like bizarre. But Europe especially is just really over the edge with the fining and getting the attention of Silicon Valley especially. And the newest development is the cybersecurity. So the government came out and said, if your cybersecurity is poor and you're involved in the federal supply chain, then we may prosecute you for False Claims Act violations. Let's go to the next slide. I'll take this one, Amanda, and then pass it back to you to wrap up.
Sure.
The Mallory case, I'm not going to read from this slide. I'll just summarize it. If you are a company that has a contract sales force and you have 1099 agents that you are paying commissions to, you need to look at those arrangements, because there was a court case not so long ago, $114 million FCA judgment, where involved a whole bunch of other nasty conduct. But one of the big points coming out of it was the government said, you're basically not meeting any safe harbor. You've got these agents out there that you can't control, and they're not employees. And so we're going to prosecute you for under the kickback statute. So I know one of our polling questions we talk about, we have a polling question, I think, on this. If someone could ask that.
We also have a question in the chat here. Do medical companies involved in FCA cases settle and pay the fine in lieu of the potential of being banned from operating for 5 years? I thought something like this was mentioned earlier, or is that strictly doctors?
Yeah, absolutely. There are exclusion rules underneath under the laws, and there's a special law just for exclusion. So if you commit healthcare fraud, you can be excluded from industry. And so typically that is such a powerful weapon that the government has that they will say, like with Howard, hey, you promoted off-label here, and obviously that Howard won that case, Vascular Solutions won that case. But they say, if you don't settle, then we'll kick you out of the industry. We'll put you in jail. We'll do whatever. And so that's the weapon. So the answer to that question is yes, that companies are forced really with their arm behind their back to go into these settlements. So who knows what would happen if a lot of these cases were really litigated. I suspect there would be some changes.
Yeah, and I'm guessing exclusion is probably part of the negotiation and the settlement as well. Because you see sometimes certain people are excluded, or the company, or certain business units within. So I'm sure that's a point of negotiation as well.
So, Paul, polling question. Do we have a polling question?
I don't think we do.
Okay.
Nope.
All right. Well, I'll make one other point on Mallory. There's ways to actually remunerate contract sales reps. You just need to be smart with it. Ideas on how you could do that. I bolded that. think about like you can't if you're not paying them a commission based on the value or volume of the referrals or purchases ultimately made. Then what other things could you do? Have key performance indicators, MBOs, management by objectives. So map out your territory, and then we'll pay you this much money. Call on this many physicians, and we'll pay you this much money. If you get asked to come back and do a second presentation, this much money. If you ultimately do an in-service, this much money. So, there's ways that you can pay those contractors for legitimate activities that are not based on the value or volume of referrals. So think about that. And that's what a lot of our clients ended up doing. They just restructure those commission arrangements. And there is an advisory opinion out there, 9933, which actually blessed a commission arrangement. But Mallory just had a lot of other facts involved that, the government, just because there's an advisory opinion out there on something doesn't mean it's like a safe harbor. So whenever you're looking at any fraud, you got to really study those safe harbors. Over to you, Amanda.
All right. So on the topic of enforcement trends, we wanted to just have a bonus topic here, just kind of some things to think about when you're faced with responding to an FDA enforcement action, and enforcement action is used very broadly here. But just, if remember earlier, Tim had talked about TLAST, so just remembering, that applies in a lot of situations. Because lying to a federal agent is prison. It's up to 5 years in prison. So tell the truth, listen, answer the question, stop talking, tell the truth. Appreciate the nature of the inquiry or action. So kind of depending on what type of inquiry it is, acknowledging and appreciating the level of attention needed. Is it an all hands on deck thing? Is it just quality? Is it regulatory? Is it legal? Do you need to call your insurance company? Like just trying to scope out who it is, and then, giving the situation the attention that it deserves. Consider whether you're under investigation and by whom. So that's important. Sometimes you'll get a call or a visit from an inspector or an investigator or an auditor, and you just want to make sure that you're clear on who you're working with, who's on the other end of the line. It could be a very different scenario if it's the FDA or if it's the FBI or the DOJ. So just kind of asking questions and really understanding who you're working with, and truly whether you are under investigation or if it's just a line of inquiry that they have maybe related to another investigation. Know when to call your lawyer. Will a regulatory attorney help? Do you need to call a white-collar crime defense attorney? It all depends on the scenario and the kind of questions they're asking.
I will say there too, quick, we're not that lawyer.
No, we're not white-collar crime, no.
We have lots of friends in that place, but hopefully we never have to have that conversation with you. But it has happened many times, more than once with clients. But anyways, keep going, Amanda.
Yep, just remember to preserve documents, or at least follow your retention periods. Don't go on a shredding rampage. That will not do you any favors. Remain calm, resist the urge to be defensive. The tone is important. You want to have kind of a collaborative, not necessarily friendly, but at least being able to have a cordial conversation and being collaborative. Consider remediation. So if there were, issues or errors or anything uncovered, or that you've uncovered through the FDA action, get the fixes in place, show progress, don't overcommit to the agency. I know it's tempting if you get, 483 or a warning letter and you say, yes, we'll have this all done in a month, and then, you go away and you're like, wow, this is going to take like 3 years. So just kind of thinking through those topics is important. Don't get too overexcited. You may detect new issues when you're remediating. That's okay. Address those, and be transparent with FDA if there are ongoing communications, and you can keep them in the loop on what you're finding and what your remediation plans look like. Don't send FDA documents that will create new issues. So again, if you detect an issue, you don't need to kind of send them, a bunch of other documents that they're going to have more questions on. So again, responding to what they're asking, but then stop in the TLAST. Consider whether reporting is required. So do you need to report to the FDA, SEC, OIG? calling your insurance carrier. Do you have government contracts you need to look at? Kind of thinking through all the different communications that you may have to make depending on the nature of the inquiry. Do you need to conduct an internal investigation? So, companies should have an internal investigations policy. Do you need to, does the enforcement activity constitute a trigger to initiate an internal investigation? Do you have an internal communication plan? If there's, something comes up, is there a crisis communication plan in place or something along those lines? Making sure that you're following up with FDA on next steps. So again, don't overcommit, but you want to lay out your plans and be transparent with them, and then, they will provide feedback if they disagree. Do not sign anything without legal consult. So yeah, if you get, something that some official is asking you to sign, politely say that you need to have counsel review it before signing.
I'll make one other comment there, man. I know we have FDA there, but we could also insert regulator.
Yeah. Yep.
OIG, DOJ. DOJ is the law enforcement agency. It could be OCR.
Yep.
The other comment is sometimes we'll get pushback from clients, maybe some of the more uninitiated, where they're like, "Well, we don't want to do an investigation because it looks like we did something wrong."
Yeah.
Well, actually, you conduct, and we conduct these all the time for clients. We'll do an investigation under attorney-client privilege. So that means we would work with the general counsel, for example, if there is one at the company, and that report is private. We don't. You have to be really careful with who we share it with, but ultimately that's our business. We don't have to share that. But sometimes we'll write those reports with the anticipation that we're going to need to share it with a regulator, so that if they uncover it later, maybe we get comfortable with this situation, we remediate it, we don't feel like reporting is necessary, but then a whistleblower brings it up later and we say, yeah, I remember that from 7 years ago. By the way, everybody will be gone by 7 years later, but you'll be at the company dealing with it.
Yeah.
And it should have a compliance folder. Then you open it up and it says, yeah, look, we hired, we actually looked at this and we got comfortable with it, and we'll show you a report. Sometimes we'll share it, we'll make a report knowing again that we're going to share it later, and it lays out our position, and that way the company appears responsible. Optics, they are important. Substance is just as important, but that can really help you down the road, because then it shows that you have a properly functioning compliance program.
Yeah. Yep. Exactly.
I think we have one more slide here, Amanda.
We do, and we just wanted to leave with a happy feeling on everybody, so that we can remediate our reputation for being in a black hole. So here's some cute puppies. Two cute puppies.
We have one question from the chat here. Is it acceptable to pay internal sales reps on commission? If so, why?
So,
well, there's an employee safe harbor.
if they're employees,
So under that safe harbor, those you're allowed to pay employees basically commission. There's special rule under the kickback statute. If you meet it, then that's acceptable. So that's a great question.
That it?
Amanda, if you have anything to add there.
Nope,
If
that's what I
not,
was gonna
we'll
say.
move on.
As long as they're employees and they are, bona fide employees and meet that safe harbor, should be good.
All right.
All right.
Any other questions?
Hey, Mark, can you hear me?
Yes, Mike. How's it going?
Good. How are you doing?
Excellent. Great to see your face.
Likewise. So I've got a question on that last point you brought up, a memo from, say, Gardner Law on a compliance topic. And let's say you want to create a memo that does become you're willing, or you would want to share with an authority down the road. How do you manage privilege so as to avoid waiving privilege on all other communications relating to the topic?
Great question. I'll respond, then I'll go to Amanda, because she's conducted hundreds of investigations. She was compliance officer of a large multinational med tech company. But a lot of times we'll create two. So we'll have our own, their ACP protected report, attorney-client privilege report, and then the one that's the LTF, the letter to file, that we may produce later. That would be my response on that, man.
Yeah,
other words,
depending on the issue, sometimes we could, we would choose whether it makes sense to keep the entire investigation privileged, or if we do want the ability to share it. And I think having two can be a good situation, or a good strategy for that. I'm trying to think. I haven't had a situation come up where we later had to share it, but I'm imagining that you'd probably summarize it and share it, or have like a separate thing. Yeah, you wouldn't want to reshare and kind of try to, and potentially destroy privilege of the entire investigation. Does anyone else have ideas? It's a good question.
Sometimes we'll also work with, obviously the corporate counsel outside, or, these, I once went to, just to make sure that ACP is maintained. And I once went to a CLE, this is years ago, but I mean, I swear, from the podium, the expert on ACP basically spoke for an hour about how ACP gets shot up.
Yeah.
And it was kind of appalling. It's like, unless your email says exactly,
I know, it's, yeah.
This, that, and the other thing.
Like, at the
it was a
request
little
of-
bit- right. Use these magic words and maybe ACP will be recognized by the government. But
Well, yeah, and it gets, I mean, a lot of us may have combined legal and compliance departments, and we do want to generate, the letter to file from within the department, but the same person who may or may not be a lawyer is generating correspondence that you do want to be either work product or, ACP. And so, if it were ultimately questioned, you have the same person on the same topic generating some stuff that is intended to be privileged and other communications that are not. Would that withstand that challenge?
it's a great question. And, not to bore you guys, but here at the firm, I mean, we have our own outside counsel that we go to and receive training on these different topics. And it's a bit of, it's a challenge. I feel like the ACP, you could do a whole CLE just on.
Yeah, no, absolutely.
It seems like, based on case law, it'll be like, well, this happened in Oregon, this was in Florida. It shifts all over the place. So
Yep.
I think some of the old tried and true points are to limit people that need to have the information. Sometimes on these reports, we'll even write, issue 1 of 3, have the person's name on it. Report number 2 of 3 goes to this person, and then right on the report in big block bolded text, it says, you can't forward this report without the GC's permission. And we just plaster it with ACP, work product doctrine, confidential, do not copy, do not distribute, etc. But so limiting the audience to who needs to know. Sometimes we'll be involved in investigations, and outside parties get involved too, or somebody's invited to a meeting that's a contractor. We're like, well, hang on, do we need to have this person there? So some of those old fundamentals that we all learned in law school, or just on grandpa's knee, I think it's wise to follow those. All right. Well, I think our time's up. If there are
Yes,
questions,
yep.
we'll turn it over to Jesse and get our panel going.